Hi everyone, today I'm going to be explaining Chapter 9 of Legal Argument for Law 301. So Chapter 9 basically puts the previous chapters together so that we can take a case, make syllogisms that create a strong argument. So like we said in the previous chapters, a lot of legal arguments consist of denying motions, and that's what the first case was about. So our goal of the first case, which is what I'm going to focus on, was to deny the plaintiff's motion to amend her complaint. So 3 years ago, a woman filed a complaint that she was being discriminated on the basis of gender, and then now she's trying to amend her complaint. And she's trying to amend it now on the basis of fraud and breach of contract. Her original complaint was under the federal anti-discrimination law. So the first thing that we need to do is research. So firstly, we need to research under what conditions plaintiffs are allowed to amend their complaints, and we also need to research cases in which plaintiffs can amend their complaints late in the situation, particularly after the close of discovery. Okay, so applying the two things that I just said, we're going to construct our syllogistic argument. The very first thing that we need to do is just know our party's alignment. They're the defendant trying to deny the plaintiff's motion. That means everything that we argue needs to be against the motion. Now we're going to determine what legal principles might apply to our case. So after doing some research, we can determine that Rule 15 of the Federal Rules of Civil Procedure apply. From there, we can develop a list of presumptive positions. The book includes 5, which I will read off quickly. The plaintiff's motion must be denied. Rule 15 requires a denial of the plaintiff's motion. Granting the plaintiff's motion would unduly prejudice the defendant. The plaintiff has offered no excuse for her delay in moving to amend, and if the plaintiff's motion were granted, defendant would have to conduct new discovery. So all of those positions are positions that we might include, but we might not. We're about to determine what ones that we can discard. Alright, so firstly we're going to work with the first position, which is the motion must be denied. We need to figure out what's going to be able to fill in for the major and the minor premise that's going to make that conclusion flow. So a possible major premise could be that Rule 15 to amend a complaint must be denied if, under 2 conditions, one being the plaintiff has no excuse for the delay and the adverse party would suffer prejudice. Under that, the minor premise would have to be that the plaintiff offered no excuse for delay and that the other party would suffer prejudice. Even though this syllogism works, it doesn't have any substance behind it, so we need to ground it. And we're going to ground it by taking one part of that major premise and making it the conclusion of a new syllogism. So we're going to work with that. The plaintiff offered no excuse for delay. We're going to take that section and make it the conclusion of a new syllogism. Okay, so working that as the conclusion of a new syllogism, we can make the major premise something like, to assert an excuse for delay in filing a motion to amend, the plaintiff must show a valid reason for his neglect and delay. And then following that direct language from the major premise, our minor premise would be that the plaintiff has not shown any valid reason for her neglect and delay. Again, we want to keep the language the exact same. And then it would flow into our conclusion that the plaintiff has offered no excuse for delay. So it's really important that we're grounding things even if we feel like they don't really need to be grounded. So technically there's no definition for what a valid reason is. So we're going to continue to cite Hayes and make a new syllogism to ground that major premise. That kind of sounded confusing, but basically what we're going to do is make a new syllogism. So the major premise of this new syllogism, citing the specific Hayes case, we're going to say allowing one's case to lie fallow for a lengthy period of time is not a valid reason to change a motion. And then the minor premise would be that the plaintiff has allowed it to because she let it sit there for 3 years without doing anything about it. And then our conclusion would be that the plaintiff has not offered a valid reason for neglect and delay. So basically, we grounded that syllogism by kind of making a definition for what a valid reason would be, and that would be to let a case lie fallow. So the only way to really ground the minor premise is to speculate that the plaintiff hasn't done anything in the last 2 years. We can kind of suspect this based on the fact that she has not taken discovery in 2 years or moved for a trial date. And so that would kind of make her a inactive litigant. She also has not provided any excuse to why she has not been an active litigant, which helps our case. Alright, so the final step is we need to ground that second part of the first syllogism. So we're going to take that second part, which says that the defendant would suffer prejudice, and we're going to make that the conclusion of a new syllogism. We're going to do this by making a new syllogism where the major premise says that a defendant would suffer prejudice by being forced to defend new claims after the close of discovery. Our minor premise, following the same exact language of our major premise, would say a defendant would have to defend new claims after the close of discovery, making it so that the defendant would suffer prejudice in the end. We don't really need to ground the major premise, so we would only have to ground the minor premise by, again, kind of defining what a new claim would be. However, it's going to be quite obvious to most judges that a breach of contract and a fraud claim is going to be much different from a gender discrimination claim, making it so that the defendant would have to defend new claims. So that is the first part of Chapter 9. The second chapter goes into the Endangered Species Act violation. It's just a little bit more of a complex scheme, but it's the same thing. I think the key point to get out of Chapter 9, though, is how to put all of the things that we've learned in the previous chapters and putting them together to make a really strong, grounded argument where the opposing side, the judge, they have to agree with you.